However, there have been some interesting cases, one in New York, the Stambovsky versus Ackley case, where a man from out of town, out of state, purchased a home that was known within that town to be very haunted. And he didn't know anything about this, didn't ask, because that's not necessarily, typical question that a buyer is going to ask about ghosts. However, once he learned about the hauntings, he wanted to get out of this contract. Now, the trial court turned this down, saying, hey, you could have done your research, you could have done your due diligence, and thinking that there might be ghosts in the house is not a reason to be able to get out of your contract. However, on appeal, the New York Supreme Court decided, they turned that around, that he's not entitled to monetary damages. However, this being a material defect in the eyes of the court, something that might dissuade a buyer from wanting to move in, and the fact that he was from out of town and could have done his research at that time. We didn't have, the internet wasn't on everybody's phone. I think this was, 1991. So he really couldn't have known that this was a problem. So they granted equitable relief, and he was able to get out of the contract. So that was interesting. New York is one of, I think, just 4 states that have this kind of law in place now, and it's still doesn't specify that a haunted house can be, that there's relief against that. And that's the first case. It's actually known as the Ghostbusters case, affectionately, where that type of relief has been offered to the plaintiff.